Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about Disaster Management Act 2005. Recently, the World Health Organization has declared COVID 19 as a pandemic. It means it's occurring over a huge geographical area and out of the control. As the situation is getting worse, the Prime Minister of India, Shri Narendra Modi, took active measures to protect the nation from this disease. On 24th March 2020, the Prime Minister Narendra Modi announced the nationwide lockdown from March 25, 2020 to April 14, 2020, and now the lockdown has been extended further. The announcement was made due to the COVID 19 and it is intended to enhance the concept of social distancing. The order was passed by the National Disaster Management Authority in the exercise of its power under Section 6, Subsection 2 of Disaster Management Act 2005. The order also stated that according to the Section 10, Subsection 2 of the Act, the Home Secretary in this capacity as chairperson, National Executive Committee issued guidelines to the Department of the Government, State, Union Territory to issue strict implementations. The centre has imposed a complete lockdown for 21 days. Under the Disaster Management Act, the Indian Home Ministry has directed that all the districts of state and borders should be sealed. Significance of development of disaster management act. At the global level, there has been considerable concern about natural resources disaster. Even if there is a substantial scientific and material progress, the loss of lives and property due to the inevitable disaster has not decreased. In fact, the human and economic losses have increased. It was in this context that the United Nations General Assembly in 1989 declared the 1998 to 2000 decade as the International Decade for Natural Disaster Reduction, with the aim of reducing the loss of life and property and to limit socio-economic damage through international action, especially in developing countries. In the past few years, the Government of India has shifted the approach to disaster management. The new approach is part of the conviction that development cannot be sustainable unless disaster mitigation is built into the development process. Another keystone of the approach is that mitigation should be interdisciplinary in all aspects of development sectors. The new policy is based on the opinion that mitigation investments are much more economic than spending in aid and rehabilitation. The emergence of an organization is always through an evolutionary process. NDMA has also gone through some phases. The Government of India, while identifying the importance of disaster management as a major concern, found the high-powered committee in August 1999 and a national committee after the disastrous Bhuj earthquake occurred in 2001 in Gujarat for making recommendations on the preparation of disaster management plans and suggesting effective mitigation mechanisms. The 10th five-year plan document has also had a detailed chapter on disaster management for the first time. The 12th Finance Commission was also instructed to evaluate the financial preparation for disaster management. On 23rd December 2005, the Indian government enacted the DM Act 2005, which provided for the creation of NDMA, headed by the Prime Minister, and SDMA, led by respective CM of the different states, to lead and implement a holistic and integrated approach to disaster management in India. Salient features of disaster management. The Disaster Management Act 2005 came to force on 26 December 2005. It permits states to have their own legislations on disaster management. That comprises 11 chapters and 79 sections. It defines disaster and disaster management in its own way. It provides an institutional mechanism for monitoring and implementation of the plans. It also ensures measures by the various parts of the government for the prevention and reduction of disasters. The Act under Section 3 provides for establishment of the National Disaster Management Authority. Under Section 14 of the said Act, the state government shall create disaster management authorities, and Section 25 talks about the constitution of district disaster management authorities. The Act also provides for disaster response fund and disaster mitigation fund at national and district levels. Since the enactment of the disaster management law in 2005, it has adopted a new multidisciplinary focus on disaster prevention and risk reduction and has moved away from a relief-centered regime. The institution structure under the law requires the creation of the National Disaster Management Authority and the State Disaster Management Authority as bodies responsible for disaster preparedness and risk reduction at the respective levels. The Disaster Management Authority of the Ministry of International Affairs maintains the responsibility for directing the disaster response overall, and instructed the ministry and department involved to prepare their own plans in accordance with the national plan. The Act also contains provisions for financial procedures such as the creation of funds, the Natural Disaster Mitigation Fund, and similar funds at the state and district levels. National Disaster Management Authority. It is an apex statutory body created for disaster management in India. It was constituted on 27 September 2006. According to the Disaster Management Act 2005, the PM acts as the chairperson of NDMA. He further appoints 9 members of the committee. The main function of NDMA is to make policies, plans, and guidelines for minimizing the effects of disasters. It also gives guidelines on the minimum standards of relief, such as to provide shelters, food, clothes, and all the basic necessities. It also lays down special provisions for widows and orphans. This authority is assisted by the National Executive Committee.